Most lawsuits to enforce the USCIS Form I-864 are brought in marriage and fiancé-sponsored cases. However, the very same affidavit of support is required in all family-sponsored cases. And in all of those situations, including parental petitions, the affidavit of support can be enforced. In all of those cases, the core facts are the same. The questions are, did the sponsor sign the affidavit of support? And what has the person's income been? If an elderly parent's income has been below 125% of the poverty guideline since they became a U.S. resident, they can potentially enforce the affidavit of support. That's just the same as somebody in a marriage-sponsored case. Probably the most significant difference in parental enforcement of the affidavit of support is a lot of times my clients are elderly and are not planning to re-enter the workforce. So instead of pursuing a global settlement where there is a cash settlement, oftentimes my client's objective is to get ongoing monthly support because they really may need to rely on that support for the rest of their life. So in prior cases where I've represented parents enforcing the affidavit of support, there is a settlement of past support that is owed to the parent. And then instead of trying to identify a specific amount of money that the parents are accepting in exchange for future support under the affidavit, instead of that, they will receive monthly payments as long as they need it and as long as the affidavit of support is in place. Hope that's helpful. I'm Greg McLawson. I'm the affidavit of support lawyer. I help green card holders enforce the USCIS Form I-864.